I'm live.
The 14A District Court is now in session. All those having business before the court drawing here, the Honorable Judge J. Cedric Simpson presiding.
And good morning, folks. Let me get my screens on here. Yep, there we go. Court does call the case of Arbor Woods versus Ruth Falstrom.
Good morning, Your Honor. Rachel Thornbush, Palace Law, on behalf of the plaintiff.
Good morning, Your Honor. Ruth Falstrom is here.
All right. Where are we now on this case?
So, Your Honor, my client did receive a $1,000 payment from Ms. Falstrom this week. I believe it came in after my client sent me this ledger, so bear with me. I'm just going to adjust this. It brings the balance down to $1,464.28.
All right. Is that what you is that correct, Miss Falstrom, from what you have?
It's just a couple dollars. I apologize, Judge. I'm sick. It's just a couple dollars more than I thought, which is fine.
Oh, all right. But we're in the same ballpark.
Yes, sir.
Okay. The problem is we're now here on the 27th and your November rent is going to become due. Right?
Yes, sir.
So well, let me ask this. How are you looking to get the 1464 paid?
I get paid on Tuesday. So I was gonna take that from that paycheck. And then I was gonna talk to the front office about I can pay more than that. I just don't know what my paycheck's gonna fully be because I've been out ill and I'm out of sick time. So I'm so sorry. So I need to talk to the front office.
All right. You're all right. Don't worry about it. So on Tuesday, you'll have this whole amount?
Yes, because I know I'll at least have that from my paycheck for the $1,464.04, correct?
Okay, so here's what we'll do. I'm going to find no tribal issue after a hearing. And I'm going to grant a judgment to the plaintiff in that total amount of $1,464.28. All right, now here's what that does, ma'am, is that locks that figure in so that on Tuesday, you'll have 10 days to get that paid. But if you pay it on Tuesday, then that satisfies you, that judgment is now over. And now you're going to work on getting your November rent and you can get yourself all caught up. You follow me?
Sir. Yes, sir.
Okay. So this is the way I'm going to do it. And we'll do it like that. Okay.
Okay. Appreciate it. Thank you.
Oh, not a problem. All right. Thank you. And you feel better. Okay.
Thank you. Have a good weekend.
You do the same.
Bye-bye.
Northfield Estates versus Mark Capaldi.
The Senate is not checked in.
They've not checked in. Should I take a default judgment? Of course she would. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. For the record, Your Honor, Rachel Dornbush, Palace Law, on behalf of the plaintiff. Your Honor, there's rent to retain of $2,002, court costs of $197 for a total due of $2,199, and we'd request entry of a default possession only judgment with writ to issue in 10 days.
Judgment to the plaintiff. That's by default for possession, redemption amount in the amount requested, writ to issue 10 days. Is that it?
That's it.
Wow.
I
think Sydney had like one case one time. This is amazing. This has got to be a record for you.
All
right.
agree, Your Honor, and since that's it. I'm with Judge Barr at 10:30, so that's it with me. That's it for me with you today. Have a wonderful.
All right. You do the same. Take care. 14A stands in recess.
Could I go in a breakout room again briefly with David?
Perry Bauer, and Ryan Comrie.
Unless you don't mind me just making a quick clarification right here. I could do that.
I mean, everybody's on.
Oh yeah, and it's streaming as well, I think.
You might text the students. Have they texted you?
Not yet.
All right, so sit tight. They will.
I'm live.
The 14A District Court is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning. And Detective Allen. Before I get to my other guys. Good morning, sir.
Good morning, Your Honor. How are you?
I'm doing okay. I understand that this is a swear out for an added count. I swear to for an added count 7 on this complaint.
Yes, sir.
In criminal sexual conduct. So court does call the case People State of Michigan versus Gary William Lockwood. Please raise your right hand to be sworn. Do you solemnly swear or affirm the information that you will provide to the court will be true to the best of your knowledge, information, and belief?
I do.
All right. If for the record, you could state your name, your department, and tell me what you know about this matter regarding count 7.
I'm Detective Zach Allen from the Ann Arbor Police Department. Your Honor, on September the 23rd of 2023, Gary Lockwood was charged and arraigned on counts 1 through 6 in this complaint, which was CSC, 3rd degree of a 14-year-old, accosting for immoral purposes with the 14-year-old's 13-year-old sister, malicious destruction of property in a police vehicle, using a computer to commit a crime, as well as 2 counts of resisting and obstructing police. As I said, that was September 23rd. On October the 10th of 2023, the 13-year-old that was previously mentioned from the accosting was participated in a forensic interview at the WCAC, and at that time disclosed that she also, in fact, had sexual intercourse with 31-year-old Mr. Lockwood. The prosecutor's office sat in on that interview, hence the amended and added charge of the second criminal sexual conduct.
Right. Based upon that testimony, the court does find that there's probable cause to believe that the individual alleged in the complaint has committed that offense and would approve the amended complaint in this matter. All right.
Thank you, Your Honor.
sir.
Have a good day. I appreciate your time.
Stay safe, please.
Thank you.
Court does call the case of listen, Blue Herring Point Apartments versus Mary Jordan. Yes.
Good morning, Your Honor. Christopher Borkin appearing on behalf of the plaintiff.
Good morning, Perry Bauer, student attorney with the Michigan Civil Criminal Litigation Clinic, requesting permission to practice under Michigan Court Rule 8.120 under the supervision of David Santacroce. Today, my partner Ryan Comrie is also in court, as well as Ms. Jordan.
All right. Permission to practice is granted. All right.
Yeah.
Where are we on this matter?
Your Honor, last week we requested a week adjournment because we were very close to a resolution. We had a hiccup, as David phrased it, and just the fine details of that were not in place until our conversation this morning in a breakout room. By next week, with a new draft of the order being sent between the parties, we will almost certainly have a resolution. In this case, barring any other hiccups, I don't foresee any others. Those details are now locked in, and any other foreseeable problems have been addressed.
Ms. Bauer, is that all correct?
Yeah, that's all correct. We're just sorting out the details of payments, and we're also optimistic that we can have this sorted out by next Friday.
Just optimistic?
What was it? Fairly certain?
Okay, yeah. Gee, that's better. Okay, so I guess my question would be, I'll put it out to whatever date. You guys are working hard on it, trying to get it done. If I put it out to the 3rd, you think you can have everything done and everything buttoned up? Or I don't have the 10th because that is a holiday. And so my next date, I had the 3rd or the 17th.
So Your Honor, to be clear, for the 3rd, we would have to have it in by next Wednesday to get removed from the docket. Is that correct? By close of business Wednesday?
That would be correct.
We could do that on plaintiff's side.
Okay.
You can do that?
Yes, Your Honor.
Oh, the student attorney was going to say that works for my schedule. Really? Shit, no, anyway, just saying, they don't have anything to do. All
It works
right.
for my supervisor's schedule.
Oh, is that what that was?
Yeah.
Okay. All right. I will adjourn the matter then to November 3rd, 2023 at 11 a.m. Okay. And if you guys are close to that time limit, just let me know and or let Miss Widely know, and I'll make an exception if it's close. So, all right.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Thank you, folks. Everybody have a great day. And I
You
see all those M's up there. I'll just say go Terps. All right. Thank you. Court stands in recess.
Hello?
And I'm live.
The 14A District Court is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
Court does call the case of Ridgewood Apartments versus GlbMwCXlRlg.
Judge, good morning. Robert Novak appearing on behalf of the plaintiff.
In your name? Excuse me, could the defendant state their name?
Oh, GlbMwCXlRlg.
Thank you. All right, where are we on this case?
Judge, the amount that's due and owing through the end of October is $2,789. I believe Mr. Carroll had applied to get some assistance, and I think we were waiting for that. He was supposed to make a payment. So I think that's where we're at. We're kind of in a holding pattern.
Okay, but you applied for assistance, and I see Amy has turned her camera on. I think she has something to tell us.
Good morning, Your Honor. I just wanted to,
Good morning.
just here on standby. I believe that he was supposed to receive assistance from SOS. There was a contract that had been signed a few weeks ago, and I'm just wanting to understand if they had actually received a payment yet.
We have not received payment. How much was that payment for, Amy?
The contract was for, or the agreement was for $3,000 for the maximum.
We have not received that. If we would have received it, there would have been $6 left and we would have dismissed it.
Got it.
How long does it? I'm sorry, Judge.
What's the monthly rent?
The monthly rent, Judge, it looks like $14.49. Is that correct,
That's
Mr. Carroll?
No, $14.90.
$14.90?
Yes.
Okay, so here's going to be the question. If I put this over, that what's going to happen is that number is going to shoot up. And then I guess my first question would be, that won't prevent the payment of the $3,000. Will it, Amy?
I don't believe so, since the request had already been made.
Well, the check has been sent out. I emailed the Angela yesterday, and the day before yesterday, and she sent me the email of her and Yvonne messages, and she was showing her that they have already sent the check out and they're just waiting for it to receive for the payment.
Okay, so the check went out.
Yes.
Okay. So I can do one of two things. I can put the judgment in place with the agreement that once the payment's received, it'd be set aside. Or what I can do is adjourn it out. If I adjourn it out, the problem is that payment will come in, but there's still going to be a.
Judge, I think the judgment, and we agree to set it aside once the money comes in, is probably going to be the better route. That way I'm not running up a bill for my client and Mr. Carroll is not having another month tacked on if we have to come back.
You got that, Mr. Carroll, what we're doing?
Not for sure. Can you quite explain it to me? I'm sorry.
Okay, it's all right. What I do is I would issue the judgment now with the agreement that that judgment would be set aside once they receive the money. Okay, because I'm worried about two things. One is that if I adjourn it out a week, November's rent is going to click in and the case is going to continue to go. Okay. The other thing that I'm worried about, while I believe that the money has been sent out, I don't want somebody coming along saying, well, he's got to pay this other part up before they really get the $3,000. I don't think that'll happen, but I don't want to even be in the position of trying to sort that out.
Okay.
Because I've seen a lot of strange things happen. Okay.
Okay.
All right. Does that make sense to you now?
Yes.
Okay. So what I will do is, yes.
I'm sorry. The amount, including court costs, is $3,006. What I wrote under further orders that the judgment shall be set aside once the third-party check from SOS clears.
Got it. Okay, so it's $3,000. So I will issue a judgment finding no tribal issue after a hearing on the matter. And then with a 10-day writ period, once that's received, it will be set aside and that'll be contained under the judgment. Okay?
Judge, you want to extend the writ date until the 15th as opposed to the 6th, just to err on the side of caution?
Yeah, I think that would be wise. Well, I think that'd be a good thing. Thank you, Mr.
Trying to make it a win-win, Judge.
Thank you. All right. Thank you, guys. You guys have a
Thank you,
great
Judge.
weekend.
Have a good day. Thank you, Amy.
Thank you.
Thank you, Mr. Carroll. Court does call the case of Beal Properties versus Rebecca Elledge.
Good morning, Your Honor. Clifton Hitchcock, Swiss Stack Levine, on behalf of Plaintiff Beal Properties.
Good morning, Your Honor. Jill Bauer here on behalf of Rebecca Elledge, who is also present. I'm from Legal Services.
I know where you're from.
I know, I was
No,
just
I'm-
letting opposing counsel, in case opposing counsel didn't know.
Yeah.
Oh, I know.
Okay.
I know too.
All right. Okay, where are we on this case?
Your Honor, Ms. Bauer and I had a chance to speak earlier today, and we respectfully jointly request an adjournment for a few weeks until November 17th, if possible. There's some matters that need to be addressed in here, including answering a counterclaim and filing an amended complaint and exchanging some documents.
All right. Is that correct, Ms. Bauer?
Yes, Your Honor.
All right. This matter will be adjourned to November 17th, 2023 at
1 p.m.
1 p.m.
Okay, thank you.
Thank you.
Okay. Thank you, Your Honor.
Thank you. And then I have Whitaker Oaks versus Kimberly Key.
Good morning, Your Honor. Clifton Hitchcock, Swiss Stack Levine, on behalf of Plaintiff Whitaker Oaks.
And I'm Hannah Camper. I'm financially responsible for 397 Black Oak Lane, Kimberly Keith's daughter.
Your Miss Keith's daughter
Yes.
is Miss Keith here?
She is not here. I'm the one who's living in the home. She co-signed for the rental property.
Okay. But the case is only in Miss Keith's name. Did you file a motion to set aside the default? Or did Miss Keith do it?
Oh, I'm sorry. Yes, I did it and it's signed under my name.
Yeah, I do see that. Okay, well, ma'am, this is a motion to set aside a default judgment.
Your Honor,
And
if I may.
first of all, it wasn't a default judgment.
Yeah.
Okay, Miss Camper,
Okay.
there was a hearing on it. I didn't find that there was a tribal issue and issued the judgment. As I read your motion to stay the eviction, you're indicating that you made payments to Whitaker Oaks and continue making payments, and that you'd be fully paid up by November 31st, 2023.
Yes, which I realize is actually not a correct date because there's only 30 days in November. So it would be December 1st.
Okay. And here's going to be the problem with that plan, and then I'll let plaintiff speak. The problem with that plan, absent an agreement with your landlord, is that come December 1st, you're saying on December 1st, you'd be paid for December?
Well, I would pay up everything. So my plan would be to pay $2,500 on the 3rd, as well as the 17th, as well as the 1st. That's every 2 weeks. That's when I get paid. And so
Hey,
that would,
all right, so hold on before you go along with that.
okay.
Counsel, what do you have as her balance now?
Your Honor, there's a current balance that I have of $8,216.40. Your Honor entered a consent judgment, of course, in September for a total of $4,205.90. My client has no confidence that the defendant or her daughter, occupant, I guess, is going to be able to come current, and respectfully request that the court denied the motion for the stay of eviction here that you issued on the 13th.
Actually, it was July 28th that we had the hearing.
Correct.
All right, ma'am. I don't see how this plan's gonna work at all. You're muted.
Okay, sorry, I don't know how to work this thing.
It's okay.
Is that because of the amount owed? Or is that because?
Well, it's because, in part, it's because of the amount owed, because right now the balance is 8,000 something, $8,216. Even if you were to pay 2,500, 3 times in November, that doesn't even take care of the current balance that's owed, let alone taking care of November rent.
Well, I did pay 1,500 to the court to file this motion.
Correct. Oh, you're right about that. So, and counsel, you should be aware, you may not be aware, she did post 1,500 into escrow on the 18th when she filed her motion.
Thank you, Your Honor.
So, but ma'am, I don't mind trying to give people an opportunity to pay things out if they can get it done. But I don't know how you're going to get this paid. What's your monthly rent?
My monthly rent is 1,500, but that's not including like all the rest of like the random fees and.
Okay. So here's what the problem is. If I just then say that the 1,500 you got in escrow, just for math purposes, is your November rent. Okay. If you pay 3,000 or 2,500 3 times in November, you still aren't caught up. And then I've got December rent.
Well, the balance should be 6,500 after the 1,500 is because the balance that I'm.
Ma'am, I hear what you're saying, and I just did my math differently than you, but we're going to get to the same spot. If it's 6,500 after the 15, then come next Wednesday, that 15 goes back in. And so we're back at 8,000. So then we're at 8,200. Then if you pay 2,500 on the 3rd, the 17th, and let's say you paid it on the 30th, so you're paying all of that in November, that's going to be $7,500. That doesn't get me to 8,200.
Okay. Well, I do get paid again on the 15th. Is that not? I can't pay the remaining with that because won't that be just left over from December?
No, okay. Look, Ms. Camper, I see what you're doing. I do see a way it can work. However, what you'd be asking me to do is to tell the landlord they've got to wait. All right. And I don't see an equitable reason or a reason why I would do that in this case. Have you tried to talk to the folks at Whitaker Oaks about that?
I've called them. They haven't returned any calls. I went in there on a Friday and she said it wasn't a good time.
Okay. All right, look, Miss. All right, let me ask this. Council, and I see that there are people from Whitaker Oaks on here. You have not issued a writ yet, correct? Or an order?
We have.
No, you have.
Yes,
You have.
on the 13th, correct.
Yes, you did. Okay.
It's been-
So,
You're on.
let me just ask you this, and if you guys say no, you say no, and that's fine. I mean, she's in the position that she's in right now. There's 1,500 currently in escrow. She's indicating that she's going to pay 2,500 on the 3rd. Is that right, Miss Camper?
Yes.
And then an additional 2,500 on the 17th. So that gets me to $6,500 because I've got 15 in escrow.
Your Honor, if I may, the actual all-in monthly rent is actually 1,867. So 1,867. That's right.
Wow. Okay. Thank you for that, Cal.
Yeah.
Ms. Camper, I don't see how this is going to work. And I realize, and I'm saying that, realizing that you'd be giving basically probably everything you have with each of those checks. But if we're at about 1,800 for the month, I'd be going into November 300 short, which means that balance is now up around 8,500, just rounding figures off. And you're going to get 7,500 in. So it's going to be 1,000 short going into December.
Okay. I have a
Yes,
current
I'm just
SOS.
not seeing a way. Go ahead. I'm sorry, ma'am.
I do have a current application in with SOS. I met with Orta, but I'm not sure what's going on with that.
When is that meeting? Have you?
I already had a meeting. I just had to forward all my information. So I just did that this week.
Okay. And Ms. Camper, if I were assured or even reasonably assured that there would be funding there that might cover a good portion of this, they'd be mad at me, but I'd tell the landlord, you're going to wait because I've got an additional 3,000 and with your 5, I would cover the 8. But I can't say that in this case. And I can't say, landlord, you're gonna wait indefinitely.
Your Honor.
Okay. Yes.
She did have an appointment at the end of August, so I don't have more information to share at the moment, but the way that things are queuing up, she's not completely outside of that realm of being able to be considered for the funding that is currently available. So I just want to share that with you.
Oh, okay, so
Her
she
appointment was
might
on
make it
the
into that,
end of
she might
August.
make it into that window.
Correct.
Okay, so
Your
then,
Honor.
yeah, hang on a second, counsel. So, but when would we know that?
I would need to reach out for further detail. Is there a way that maybe I could communicate with attorney to let him know where the status of her application is and where the case is?
Okay, so go ahead, counsel. I'm sorry.
You certainly can, ma'am, and I give you my contact information.
Thank you.
I mean, to your Honor's point here, though, there's just no certainty. My client's been waiting for some time, as your Honor knows, and I just don't see a path forward. If there was a path forward to potentially having Ms. Keith come current, we might be open to it, but we just don't see it.
Right, and here's, let me just do this here. Ms. Camper,
Yes.
Anyone else have anything to report?
would you have access to $400?
Yeah.
Yes?
Yes.
Okay. So, counsel, the only way I see this even remotely happening is this. She'd have to pay the 25 on the 3rd, 25 on the 17th, and somehow she's got to get the 25 in on the 30th. If there is funding and she were to receive the maximum, just saying, of 3,000, then that's the only way forward on this. So here's my thought. My thought is, if this is put out a week, we can try to make a determination as to whether or not she's there. I would not want the landlord to be put in a position where another month accumulates. So if she comes up, what you said it was 18 something, 18?
Yes, 1,867, 1867.
Okay. All right. And so what I did is I just rounded it to 400. So if she gets 400 in and I release the 1,500 in escrow, this balance doesn't get worse while we see if that 3,000 is available. Because if the 3,000 is available and she makes those other payments, it actually can happen.
I see what you're saying, Your Honor. I seriously, question whether she can make those other payments happen, but I see what you're saying.
Yeah, that's a lot of contingencies, but I think as we sit here today, if I were to give it a week and can make sure that the landlord isn't placed in a worse position than you are now sitting here, right? Then I guess I'd be willing to try to take that chance. Especially since she's on the cusp of the funding part. If the funding part were way down the road, then yeah, that wouldn't happen because the 3 is necessary for it. But I think we would know in a week whether we're there. So
she have an issue though, excuse me, Your Honor. Pardon me. Wouldn't she have an issue though? She's not on the lease. I understand she lives there, but I don't know that she may have an issue with the funding not being
yeah,
lease.
you're right. Good point. Amy?
Is there a way to add her on as an occupant?
I am an occupant on the lease.
Oh, okay.
You're just not the signer of the lease.
Yeah. Well, I mean, I did sign all the paperwork when I did the lease because my mom was unavailable, but it is technically in my mother's name as a co-signer. Well, I was supposed to be set up as co-signing.
You're a member of the
Got it.
household that's named.
I only
That's
have,
okay.
I only have Kimberly and Keith as resident. That's all I have at the lease.
Police, if you look at all of the initials, it's gonna be mine.
I don't have that. I just have Kimberly and Keith. So,
And I don't think I have, oh, I do have a copy of the lease. No, well, I have the
Is-
demand for possession. Hold on. I have her as an occupant.
she's an approved, yeah, she's an approved occupant, correct? But it said there's no co-signing, it's just Miss Keith as the resident. I think she's gonna have an issue with the funding, perhaps.
Not if she's an occupant. Am I right, Amy?
Yeah.
That's my understanding as well, but Your Honor is saying.
Yeah.
I'll have more answers to those specifics.
All right, because. All right, folks. I spend all my days with people mad at me, so somebody's gonna be mad at me, but I guess that's why I get the big bucks. Here's what I'm gonna do. Ms. Camper, when can you get the 400 in?
You want it before the 1st? Is that what my understanding was?
Yeah, I need it yesterday, if you can do it, but
Okay. I can just turn it into the office, you're saying? I can turn it in for Monday morning.
is their office open where they can take the payment? I want to make sure it gets there.
I'll defer to was that our office?
Yes. Yeah, we are
Okay.
open to take payments.
Thanks, Linda. Okay. I
Oh,
thought so.
Miss, when are you gonna get that there?
I can pay it tomorrow morning.
Tomorrow morning?
Yeah.
Okay, you guys gonna be there tomorrow morning?
Linda.
Tomorrow morning, we'll be open at 10 a.m.
Okay, so I'm gonna put defendant to pay $400. I'm rounding up, but and that's what is tomorrow, the 28th? October 28th.
Yes.
2023 to the landlord. All right. I'm going to release.
Your Honor, if I may, on the
Yes.
400, that must be by ready funds, money order or cashier's check or certified check.
Right. Are you going to be able to do that, Miss Camper?
That's fine.
Okay. I'm going to release the $1,500 to the landlord that's in the court escrow. That covers us. My purpose in doing all of that is that covers November so it doesn't get any worse. Where SOS is, or Amy's going to check to see where she is on assistance. And see if the $3,000 or whatever the max would be available to her. Miss Camper,
Yes.
on the 3rd, the 2,500 that you said you could pay on the 3rd,
Mm-hmm.
what time can you get that paid on the 3rd?
What time is the court? You just want it in before the court hearing, I'm assuming, right?
I want it to the landlord before the court here.
Okay.
Because that's going to have the 400, so that you understand, Miss Camper, the 400 and the 2,500 are going to have a great bearing on what the court does if I
Okay.
adjourn this out 1 week. So you need to tell me, when can you get that 2,500 into them?
10 a.m.
10 a.m. on the 3rd?
Yep.
Okay. So defendant to pay $2,500 on November 3rd, 2023 by 10 a.m. Now let's see, what is their block on?
Your Honor,
At noon.
if I may.
Okay. Go ahead. Yes, sir.
For the 2,500 on the third, also in ready funds.
Yes,
i.e. money.
she understands that, I think.
I understand. Okay. Just making sure.
So then what I'll do is I'll adjourn this then to 11/3, 2023 at 12 p.m.
Okay.
So, all right. So, folks, so here's what's happened because, like I said, everybody can be mad at me, but what the hey? You're going to get 400 to the landlord. Our 1,500 will be released. That, in essence, if we do, however we do our math, that's going to be November, so we don't run up this number. We're going to be checking on SOS regarding the status of that, of any type of assistance that might be able to come to you, whether or not you're going to fit in that window. And then you pay the 2,500 on the third. Okay, now Ms. Camper,
Yes.
I'm walking out on a limb on this. Okay. All right. Council's mad at me. The people of Whitaker Oaks are mad. Everybody's mad at me. Okay. So I'm walking out on a limb. I need you to understand this. If those funds are not paid, I'm not hearing anything else. I'm just not even, I'll normally listen to people, but I'm not going to be listening to anything else. I'm just going to deny your motion and let them go forth with the writ.
Okay.
You understand that?
I do.
All right. Very good. Okay, folks. Thank you.
Oh,
thank you, Your Honor.
Thank you, Amy.
Your Honor, if
Amy, did you need to go into a breakout room with Miss Camper?
I could speak to her real quickly, but actually I needed Mr. Hitchcock's contact so I can keep him in the loop.
Okay. I think you guys will be able to do that because Whitaker Oaks versus Aido and Whitaker Oaks versus Poor, those matters are dismissed. So he's done.
Correct.
I'm going to go off the record and you guys can talk and share whatever information you want. All right.
Thank you, Your Honor. You have a nice weekend.
Thank you. Have a great weekend. 14A stands in recess.
Amy?
Yeah, just want to make sure that we really are off. Okay, can I have your email address real quick and I'll get that?
Sure. C Hitchcock. So that's CHITCHCOCK at SwissStackLevine.com. SwissStackLevine.com.
Okay, I'm just going to read it back to you. CHITCHCOCK at SwissStackLevine.com. Okay, I'll reach out to Autumn and figure out what the status of this is. I did want to inquire, because the amount is so huge, I didn't realize it was at this stage. Is it a way for, is it too late for her to be in some sort of a COD status where the portion that is owed above is secured in some sort of what she has stated her payment plan?
Go ahead. Repeat that, Amy. I'm sorry.
Yeah. Is it possible for her to enter into some sort of COD where her payment plan is secured and the amount of the 3,000 would then be added into that? The limitations of the program is that because the amounts, when they're always over that 3,000 portion, they want to ensure that that portion above will be paid. And in some cases where the amount is so huge, the agency has been allowing it to be secured in a COD. So they don't have ready money right then. But if it's written down and secured in a legal document showing that I'm going to pay this much by this date and this much by this date, and it's agreed upon by both of you, it allows the agency to be confident in securing that portion of the maximum allowed, which is 3,000, and then sending that over.
I mean, that's I can have that discussion with my client. I can't.
Thank you.
Firm answer at this point.
Okay. All right. Yeah. So those are the parameters around her specific case.
Okay.
That's been the way that we can I get that final amount that is as of today being owed?
Yes, you may.
Oh, you know what? I think we are still streaming, so I do want to, if there is a,
I have through October, $8,216.40.
okay, all right, very good.
Okay.
Thank you so much, Mr. Hitchcock. I'll be in
But
touch with
that's,
you over the week.
I don't know, that may not be, that doesn't include court
Mr.
costs
Hitchcock,
though.
I don't mean to interrupt you. You guys are not in a
Okay.
breakout room. Would you guys like me to put you in a breakout room so you can continue talking?
I think we're done. I think we're
good.
done.
Okay.
We're good. Thank you though.
Okay, all right.
All right. All right. Thank you,
Okay.
Amy.
Thank you so much.
Have a good one. Bye-bye.
Thanks. Bye.
I am live.
The 14A District Court is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
Court calls the case of Glencoe Hills versus Angela Newkirk Tucker and Craig Tucker.
This is Angela.
Good afternoon, Your Honor. James Fink for the plaintiff.
All right. And who do I have for the defendants?
Angela Newkirk Tucker.
All right. And where are we on this case? She was to pay $16.29. Did you get that done?
I paid that last week. When we had court last week, it was paid then. I owe the late fees and fines.
She owes a total of $507.20, Your Honor.
Correct.
Oh, $507.20.
Yeah, for late fees and fines.
Okay. So when do you think you can get that paid?
I can pay it on November 3rd.
Ooh.
Okay. So let's do this then. I'm going to lock that figure in for you. So I'm going to find after hearing no tribal issue. I'm going to grant a judgment. I'm going to grant a judgment for possession to the plaintiff in the amount of $507.20. And then you'll have 10 days to get that paid. And then you got to, this doesn't include your November rent, but this way the judgment won't include your November rent. Okay, fair enough?
Okay. Yes, sir. Yes, sir. Thank you.
All right. Thank you.
Thank you, Your Honor.
Glencoe Hills versus Jerome Adams.
James Fink for the plaintiff.
Gotcha.
Jerome Adams, they're not here. Would you like to take a default, sir?
Yes, sir.
All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
May proceed.
Your Honor, this is an action for non-payment of rent. Mr. Adams owes $483.38 in rent. The costs are $158. We request a possession only judgment in the amount of $641.38.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days. Glencoe Hills versus Donald Ward.
Yeah. James Fink for the plaintiff.
Mr. Ward?
Yeah.
Okay. How much does Mr. Ward owe?
$450.62.
Okay. Mr. Ward?
Yeah.
When do you think you can get that paid?
Okay, the last time I was here, the judge said he's gonna work out something because they was charging me like late fees and everything else, but the whole problem was no one gave me notice that my rent had been raised.
Right, I remember. Okay. So are you telling me you need time to get that paid?
No, I can pay it, but I'm saying, the late fees, and then, what are their obligation come in to let me know it been raised? Ain't no way in the world that I would have option to go to court, pay court costs and late fees had I known.
Okay, Mr. Fink, you know anything about that? We were dealing with this the last time. He says he didn't get notice of a rent increase. And then there were late fees that were added on afterwards because he didn't pay the amount.
Well, one second, Your Honor. He signed a new lease in July that took effect in August. And let me get to the ledger, but it looks like the rent went up as a result of his new lease.
All right, you hear that, Mr. Ward?
Yeah.
Actually, Judge.
Okay, yes.
Like his rent's gone down again. it did go up, and his rent in September was $368. And then it went down for October to $223.
Your Honor, this cost, okay, like I say, when it went up, the whole problem, it wasn't a matter of me not paying it, but you know, me not knowing, and the only way I found out was when I got October's rent for $517. I don't get $914 a month. That's when I found out. So I called him and asked him, how is it quadrupled from 88 to 517? And that's when she told me it had went up, you know, and I'm like, well, how come didn't nobody notify me whose job it was? She said it was CMA, so I called them and they said it was their job, you know, so it's back and forth, and that's how we end up in court, because I ain't getting them concrete.
Okay. But it appears, so Mr. Fink, what hasn't been paid? What constitutes this 450.62?
Well, there is the most recent addition were the late fees for October. And utilities for October, and looks like October rent, looking at it, let's see. He did make a payment on the 1st of October to,
Yeah, for the 23, which I was told then, you know, from CNA, it was 23 as opposed to 35. Lisa had said it was 235. So when I called CME, they said it was 223, and I paid that on time.
he did make a payment on the 1st of October, Judge, but he had, the court costs are from September the 25th, which must have been the date that we filed it. And his balance then, looks like when we filed it, his balance was somewhere around 300, can't quite tell. And then he did make one payment, but he was in arrears when he made the October payment already.
Yes, because I wasn't notified of the September raise until October.
You want to go?
But you signed the lease.
Yeah, I did.
Okay, and the lease had a figure in it.
The lease I signed was way before this raise.
And Mr. Ward, what would you want the court to do?
I think it'd be fair to both parties. You know, like I said, you know, they didn't notify me, and they, you know, sending me back and forth. And then on top of that, they added what?
Okay, but what do you want me to do?
Dismiss the late fees and the court call.
Well, no, you get the court costs. The court costs are actually proper.
Okay, all right.
How much of that's late fees, Mr. Fink?
Well, at least 150.
All right, so here's what I'm going to do. I'm going to take $50 off of the late fee. I'm going to grant a judgment to the plaintiff after a hearing in this matter for a total amount of $400.62.
All right.
So that's what you need to pay. Okay, Mr. Ward?
All right.
Your Honor, I'm going to mark line 10 that the late fees were reduced $50 by the court.
Yes, that's right.
Thank you. Just so we can keep track.
Okay.
All right. Thank you, Mr.
Honor.
Ward. Get that paid. You got 10 days to get that paid.
Okay, now they say it went down again, so what is the November rent?
I don't know, Mr. Fink.
I do not know that. Sorry.
All right. Mr. Ward, why don't you go over to the office and ask them what your November rent is, okay?
Okay, yeah, I can do that, thanks.
All right, thank you. Gulfside Lakes versus Alina Jones.
James Singh for the plaintiff.
I'm here.
Okay, she's here. All right. So we ordered the escrow paid out to the plaintiff. And then, well, how much is owing on this?
544.19, which is the same
As the judgment.
for let me just, looks to me like either we have not received the escrow or it hasn't been transmitted 233.
Right, there's 233 which paid out by us on, well, there should have been 173 received. Oh, it was October 25th. We paid it out. So yeah, you're not gonna have it.
Oh, actually, they that's been credited, Your Honor, because the ledger I have shows she owes 778.81.
Got it.
And we're now claiming 544.19. So it looks to me like that. Oh, escrow.
The
fund.
escrow got credited.
It also says my client's willing to do a COD with her if she wants.
All right.
Going to pay it, and we could set it aside when she satisfies.
Ms. Jones, are you interested in doing that?
No, I don't have the money and I actually can afford to stay here. I've been in communication with RPI and Melissa at Gulfside. And all I'm waiting for is a landlord packet so I could proceed to move from our landlord packet from RPI. So Melissa is trying to help me with RPI to get me the landlord packet so I can move. So I did a plan and my hands are tied right now, Judge Simpson. I did what you said and I have a plan. I found a place. Now, all I need is the landlord packet. And now RPI is saying I should have put it in 30 days ago, but I didn't know that. So what?
Okay, so when are you gonna move?
When I get the landlord packet and get the process going. I want to unpacking, but I just need that landlord tenant packet from RPI. Can you help me, Judge?
Well, I can't, but so I guess my question is, if you're moving, you don't intend to do anything about this balance.
I can't, I don't have the income.
Got it. I mean, I hear you, but I guess the question becomes, when are you going to move then? I mean, it's going to be one of those two things.
It'll have to be, I have at least, I would say like 3-4 weeks because I have to wait for RPI to inspect the new apartment that I have to get into when I receive all the documents to be able to proceed and go forward, Judge Simpson.
Your Honor, I haven't known willing to do a COD, so what about a 1-week adjournment?
All right.
We'll either we'll work it out or we'll be able to add November rent to the amount due.
All right. So here's what I'm going to do, Ms. Jones. I'm going to adjourn this case out to November 3rd, 2023 at
Oh, Your Honor,
1 p.m.
I'm sorry. I don't think this isn't a new case. This is a motion to set aside.
Yeah.
I think it is actually the motion. Well,
yes, it's a motion to set aside.
Set aside, it is. Which is why we had the escrow in.
Let's still set it over a week.
All right. November 3rd, 1 p.m. Okay, Ms. Jones?
Yes, sir.
All right, we'll see you then, or at least talk to you then. We haven't seen you.
Have a good
All
weekend,
right.
Judge.
You too.
Thank you.
Gulfside Lakes versus Kimberly Fuller.
James Fink for the plaintiff.
Ms. Fuller?
Judge. Yes.
Hello.
Hi.
All right.
Your Honor, can we go back to Ms. Jones? The bid on the 9th. So I'm assuming that.
Pardon?
We submitted a writ on the 9th. So I just want to.
On who?
Flagged on Ms. Jones.
You did?
That's what my notes say. I don't know that it's been issued. Just don't want it to get issued accidentally.
Second, I'll get the file back and.
Oh, it has been issued.
You don't see it?
Oh, I'm sorry. I have a copy of what we submitted. I don't have a copy back from you.
It's probably down there waiting to be.
It has not been issued by me. I don't have it in the file.
All right.
They're down there processing it. In fact, I have it right in front of me. So.
Okay.
It has not been issued.
That'll work. If we don't get it worked out next week, I'll ask you to sign it.
All right. Real good. All right. On Ms. Fuller's case, we were at 870.59. Where are we now?
870.59.
Ms. Fuller?
Yes, this morning I submitted a money order for 400, and then they were switching their online portal, and I was supposed to be able to get on there today, but I was unsuccessful because I have the remaining balance of the 470.59. So everything should be paid today if I can get online and be able to pay it.
Okay. So you think everything's paid? You'll have everything paid.
Yes, as long as I can get the website link to get online for their new portal, I'll pay the rest. But yeah, I dropped off the $400 money order this morning underneath the door of the office.
Okay, so here's what I'm going to do. I'm going to adjourn this to the 3rd at 1 p.m. You should have everything paid. If you get everything paid, they're going to dismiss the case. If not, then we're going to be talking about this balance plus November. Okay?
Okay.
Kim, you got to have it paid by Tuesday.
Yeah, you got to have it paid by Tuesday. So.
Yes, does a lawyer, Mr. Fink, do you have the portal to be able to get on the new website?
I do not. I'm sorry.
Okay. All right. I'll check with Melissa.
I'm not trusted with it. Smaller.
Okay. Thank you.
All right. Thank you, Ms. Fuller.
Bye-bye.
Gulfside Lakes versus Diamond Williams.
James Fink for the plaintiff.
Go ahead, Ms. Williams.
Diamond Williams, you're not here. You may proceed.
Your Honor, this is an action for non-payment of rent. This defendant owes $1,539.22 in rent. The costs are $159. We requested a default judgment for possession only in the amount of $1,698.22.
Judgment to the plaintiff. That is by default for possession, redemption amount in the amount requested, reissue in 10 days. Gulfside Lake versus Sarah Brown. And
good afternoon, Your Honor. I'm here.
Oh, there she is. Okay.
Yeah.
All right. I thought she was going to get everything paid in full today.
Well, I was trying to make a payment today, but the portal, I'm having an issue because they were switching over to a new portal and you can't go on there and make a payment at all. They said the new one's supposed to come out today. So I called and spoke with the Zach today because they was rearranging the new portal. So I couldn't make no kind of payment or anything today.
Okay. So let me ask you this. You're going to pay everything, right?
Well, today I could put $1,500 down and I could pay the rest in 2 weeks.
Whoa. Okay. That's not what you told me.
I know something came up. I had to do some work on my vehicle. I'm sorry. But I have 1,500 to give them today.
All right. So.
And I was trying to pay that this morning, but Zach and them said the new portal didn't come out yet, but they'll send us all an email today when we can go on and make a payment.
Okay, so here's what I'm gonna do to try to lock the figure in. When are you gonna? You're gonna have the whole balance paid by what date?
The whole balance to be paid by November the 10th. I'm making a payment today, and then I'll pay the
No,
rest
I know,
off.
I know,
okay.
I hear you. I hear you.
Okay. Yes, sir.
So what I'm gonna do is this. I'm gonna issue a judgment for possession, finding no tribal issue after a hearing. Mr. Fink, what is the total amount including cost?
2864.90.
That's including November's rent, the 48. What my balance is right now is $2,864.90.
That's what he said.
Oh, he said what? I'm sorry, I didn't hear him. I thought he said 4,000.
No.
Oh, I'm sorry. I'm sorry. You almost gave me a heart attack.
That's okay, Ms. Brown. I don't listen to Mr. Fink either. So it's $2,864.90.
Yes, sir.
Okay. So I'm going to issue a judgment for that amount. That needs to be paid. Well, 10 days will put you short of the 10th. But what I will do, that's a court holiday. So I have to give you a writ to issue the 13th. So you get the 1,500 paid in, and then you'll have to the 13th to get that amount clear. And then you'll be working on November.
Okay, yes, sir. Let me write this down.
Your Honor,
Thank you so much.
Jalen Brown.
Yeah, that's my son.
And right, and that'd be a default as to Jalen Brown.
Right. No, I'll make sure it's taken care of. Thank you so much.
All right. Thank you.
Uh-huh. Do I have another court date or just, I'm sorry. Is there another
court date? You want another court date? You want to come back?
No, I don't.
You just want to come back and see me.
No, I don't. Bye-bye.
You are just trying to come back and see me. I just finished everything.
Okay, bye-bye. Have a good afternoon.
Miss Brown, have a good weekend.
Okay, thank you.
Court calls the case, Gulfside Lakes versus Zayla Walls.
Hi, yeah, I'm here.
Okay, hello, Miss Walls.
Hi.
I had a balance the last time of 3849.32.
That's what it is today, sir.
Okay, Miss Walls, how are you intending on trying to get that paid?
I was just wondering if I could just vacate.
Okay. You'll have to talk to the landlord about that, but here's what I'll do. When were you intending on trying to leave?
November 6th.
That'd be within your writ time anyway. All right. So here's what I'm going to do. I'm going to grant them a judgment for possession, finding no tribal issue after a hearing. Total amount to redeem the property is $3849.32. If you pay that, then you can stay. If you don't, then you need to vacate within 10 days and you'll be, if you're out by the 6th, you're going to be good. Okay.
Okay, so yeah, so I'll be able to like move stuff and before the 6th.
Yes.
Okay, thank you.
Thank you.
All right, bye.
Bye-bye. Old Town Realty versus Jessica Green.
James Fink for the plaintiff.
Jessica Green, not here. You may proceed.
Your Honor, this is an action for non-payment of rent. This defendant owes $6,791.75 in rent. The costs are $238 for a total of $7,029.75.
Yes.
if she can come up with a payment plan, they'll work with her, but I'd like a judgment today.
All right. Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested. Writ to issue 10 days.
Thank you. That's
Thank
possession,
you.
right, Your Honor?
Pardon?
That's possession only. We don't have personal service.
Substituted service.
Thank you.
But hold on.
See if
No. But she did appear on the 13th. So you get possession and money.
Thank you.
Peninsular Place versus Victoria Cox.
Good afternoon.
James,
Hello. Okay. Let's see. I was at 906.90 last week. Where are we now?
806.90.
Okay, so we got 100 paid in. Is that right, Miss Cox?
That is incorrect. There was 100 paid. There was a payment made for $100, but there was also a payment made yesterday for, I'm looking for the transaction. I believe it was for over 600. I can't remember the exact amount. But there was a payment made yesterday.
Of about 600, you think?
I can log into my portal right now and try to give you the exact amount for you.
From yesterday afternoon, Your Honor.
Yesterday afternoon?
Yes,
Correct.
sir.
Okay, so what's her, you had 806. But is she,
My balance should be cleared. I did pay everything. I do know that.
Did you include legal fees, ma'am?
probably
That
not.
I did not, because I was unsure if I was supposed to pay that to Peninsular Place or if I had to pay that through the courts. That was the only part that didn't get paid.
Okay, so that needs to be paid.
Your Honor, do you want to? I'll try to get a message to him.
Pardon?
You want to pass it and I'll confirm that amount?
Okay, yeah, we'll do that, okay? So I'm gonna pass your matter, ma'am. We'll get right back to you, okay? Just a
Okay.
minute. Peninsula Place versus Brianna Fishel.
James, plaintiff.
Ms. Fishel? Brianna Fishel? She's not answering.
Yeah. I think she might be having an issue with her microphone because she's muted and unmuted twice now.
Oh, she has.
Yeah.
So see if.
Hey, Judge.
Hello.
Sorry, I'm
What-
not heard, but my name is Jessica Green. I was logged in, but I couldn't unmute. This was I had to dial in because Zoom wouldn't let me in. So I had to dial in. I couldn't unmute.
Okay. You're
So
just
I'm
hang
here.
on. Let me see if I can grab the file back. I'm gonna make you wait just a second. I'm gonna make you wait just a second, Miss Green, okay? I'm
Okay.
looking for Miss Fishel. Brianna Fishel? She's unmuted. Ma'am, do you have a camera? You're unmuted, but we can't hear you, Miss Fishel.
She's asking if she should log off and log.
Sorry, no.
Oh, log back off and
it's-
log back in. Why don't you try that, Miss Fishel, and I'll pass your case, okay? Yep, she logged off. All right, court recalls the case, People versus Jessica Green.
James Sink for the plaintiff. I think that's Old Town v. Green.
Oh, yes, Old Town, I'm sorry, versus Green. Miss Green? Now you're muted again. Hit *6 on your phone.
Yes.
There you go.
Yes, can you hear me?
Yes, I can hear you. Can you hear us?
Okay. Yes.
Okay. I issued a judgment for $7,029.75. Okay. But my understanding from Mr. Fink is that they're willing to work with you on terms of a payment plan if that's what you want to do. But
Yes, it is. I emailed them a couple times. I haven't asking this, and I haven't got a return. I haven't got a return back yet. For them, like an answer back. So I'm happy to do that. I am working on getting outside help, like DHS is helping, and then I'm applying for something else because they only pay minimum amount. But I've been telling them like for half year that I couldn't get help without the eviction notice. So, and they're just now doing it. So now I'm in the process.
here's what I'll do, Miss Green. What I'm going to do is I'm going to leave the judgment in place, let you work with the landlord on this, and see if something can be worked out.
Well,
Go ahead.
Can I ask a question then? Because if you leave it in play, that means I only have 10 days to come up with a payment plan. And if their payment plan is 10 days, pay it all off. I know I'm not going to be able to have that because the other place.
Hold on. Let me finish. I'm going to leave the judgment in place, and I'm going to give you till the 17th to work out a payment plan that you can work with them, and that'll replace the judgment.
Okay. Well, when I work. Okay. So do I come back on the on the 17th then?
No. You work out with the landlord a payment plan, and then they'll either file an amended judgment or something with the court to let the court know that you guys have worked out something. But I'm giving you guys time to do that.
Okay. I appreciate you. Thank you so much.
All right. Thank you. Have a great weekend.
You too. Bye.
And Mr. Fink was going to call on Cox.
Official logged off and did log back in.
Okay, Ms. Fishel. Recall the case of Peninsula Place versus Brianna Fishel. Ms. Fishel?
Okay, can you hear me?
Yes, now we can hear you. There you go. We got it worked out.
Yeah.
Okay. All right. Mr. Fink, how much is owing on Ms. Fishel's account?
904.33.
I'm sorry?
904.33.
Right.
That's interesting. Looks like it went up.
Yeah. Ms. Fishel, you were waiting on a payment.
It's like
you were waiting.
I'm sorry,
Go
Judge.
ahead. I'm sorry.
We added court costs of $217, and it looks like she paid something that took it back down.
Yeah, I paid 200. I want to say the other day or yesterday.
Yeah, she said she was going to pay 200.
So,
and you're waiting on something from the VA. Is that correct?
Yeah. Yes, sir.
Do you have any update on that?
Yeah, they said that it was going to come November 6th, and then I was going to pay off October and November.
Okay. So the amount that you're going to get is going to pay October and November?
Yeah.
Okay, so let me do this. I have 904.33 owing. I'm going to grant them a judgment finding no tribal issue after a hearing. I'm going to lock that figure in of the 904.33. Okay.
Mm.
And then, oops, let me write this down. 904.33. I'm going to extend your writ date because I know you're waiting on something from the VA. And the end of the week, the court's closed. So your writ, nothing will happen until the 13th. So they just need to get that paid. They'll be paying your November rent, and then you should be all set. Okay.
Yep. Okay. And then the court fees, I make that payment. Can I do that online to the court?
Well, you could pay that entire 904.33 online.
Okay.
All right, to the landlord. Okay.
Yeah.
All right. Thank you, ma'am.
Yep. Thank you. Have a good day.
You too. All right. And I don't know if you had a chance to get through on Cox yet or not, Mr. Fink.
No, could I mute myself? I did a text. I didn't get anywhere. I'll mute myself and make a call, Judge.
All right, very good. Court is standing in brief recess.
Is the court still in session?
No, it's on a break.
Oh, okay, thank you.
Where is he at?
I'm live.
The 14A District Court is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
Recalls the case of Peninsula Place versus Victoria Cox.
Your Honor, she owes $217 in costs is all.
Okay. Ms. Cox, when can you get that paid?
I can pay 100 of that today, or what was 116?
217, ma'am.
217. I can do 117 today. And if possible, I know for a fact that I could do the remaining 100 by the 3rd.
By the 3rd. I hate to issue the judgment.
Your Honor.
Yeah.
Can I put a placeholder in that even though the case is being dismissed, she's responsible for the cost, and if we bring it up in another case, I can make the argument that she owes the cost for this case and remind you?
Yes. In fact, if you,
but we won't enter a judgment today.
Okay, so it's going to be dismissed, and then
I'll send in a dismissal, and it will on the dismissal, I'll say that she owes 217 in costs as of today.
Okay, very good.
May I
Okay, Ms.
interject?
Cox, will that work?
So it's being dismissed.
Yes, it will be dismissed, but you still owe the 217. So
I
pay the
gotcha.
117 today, and then the 100 on the 3rd. That'll take care of that part, and then we'll be done.
Okay, and is that paid to Peninsula, or do I pay that directly to the courts?
Pay that to Peninsula.
Okay, cool. I will actually try to see if I can get that in sooner than Friday, but definitely.
Okay, so what I said was cool?
Yes.
Is that what you're saying? Okay, see? All right, so all right. Thank you, Ms. Cox.
Thank you, and you have a blessed one.
You do the same. Case dismissed.
Thank you, Your Honor.
All right. That's that. Then court does call the case of Rose Community Management versus Kenneth Harrison.
James Fink for the defendant. Mr. Harrison is here by phone.
Good afternoon, Judge Mark Wasbury for plaintiff.
All right. And what are you two doing? I guess I shouldn't have put it that way.
You're holding escrow. Mr. Harrison believes that he's entitled to a portion of that escrow due to the fact that he was, even though this was a voluntary move in one sense, he suffered expenses, including moving expenses, as a way to resolve this case, and he would like a portion of that escrow back.
Judge, moving expenses were not negotiated with the CD. On the books and records of Rose Community, he owes $1,869 because he didn't move out timely. Apparently there's something being held in escrow. I don't know when that was paid in, but I guess if he was paying escrow, he acknowledges that he was still there. We didn't get keys till September 6th. He was supposed to move in June. So we did apply a security deposit, which technically was going to go back to Mr. Harrison via the court, according to the CD. That was $305. But after applying that security deposit, we still have a balance of $1,869. And I think there's less in escrow. I don't know exactly how much is in escrow, Judge.
Trying to get a total right now, but
I don't think he got that 305. Your Honor, you released that to help with moving expenses, but I don't think he ever got it, but he can tell us for sure. But part of the delay, Your Honor, was both work and every time he folks to help him move the freight elevator to take him from the floor, the upper stories down, was unavailable or was only available for an hour at a time. And as you know, Mr. Harrison, who's a United States veteran, suffers from diabetes and has dialysis more than once a week. And it's not as if he can just jump up and move anytime he feels like it.
Understood. The CD gave him 2 months to move, Your Honor. The negotiated CD gave him 2 months.
So I have $1,764 in escrow, and it was deposited March through August of 2022.
1764.
Yeah, and there was many other,
But those were paid out.
but they were paid out, and those were actually paid out. They were deposited after these ones.
Yeah.
Paid out.
Right.
So,
Okay. So I have 1764 in escrow. So how much is the defendant looking to offset his moving expenses?
Mr. Harrison, what are you asking the court to do for you?
Half of the escrow, I deposited $5,329 in escrow.
Right. Part of that was paid out. What I have left is 1764.
Okay, Your Honor, but I never received the moving expenses that were agreed on.
Judge,
And
that-
because
We're asking for 600 of that. Or 900 of it, excuse me, bad math.
Judge, that wasn't negotiated. Had he moved out timely, he would have been in a better position to make this argument, but he took months beyond the months we already gave him.
Well, I guess my question is, the amount, the 1867, that accumulates from what months are you talking about?
Well, he had a balance going during the pendency of the action. Because I think initially there was about 1,500 being held by the court. Or more than that by the time we got to a CD. And I think the court was holding back 1,500. So to the extent there's 1764, it sounds like he paid one additional month into that escrow. According to the CD, 305 of the 1,500 was to go back to Mr. Harrison. Resolving all claims to the security deposit. So we kept his security deposit as we were allowed to do. All claims were resolved. And after applying that, we come up with 1869. So 1764 sounds like 1,500 plus 264. The 264 was his rent at one time.
So if I'm hearing you correctly, he, out of that 1764, he should get certainly 569 of that. Because he shouldn't have paid that last month in, and he gets 305 back.
Well, 305 he gets back, that's security deposit. I think he stayed beyond the months that he paid escrow. I don't know when he last paid escrow into the court, but he did not move until September 6th or turn in his keys. So to the extent
I don't know when he paid last either. I can tell you that he was incredibly faithful in paying escrow, even when I was trying to get him to stop.
So at a minimum, we are owed for August, Judge. If he voluntarily went in and paid it, he knew he was staying there. He knew he didn't hand in his keys. This wasn't a mistake on his part. We'll give him the 305, Judge, but I don't think he Should get any more than
Well,
that.
you have to give him the 305. That's not an issue. The issue is me.
Judge, I can't tell you the number of times he called me complaining that he used the elevator and had to reschedule his moving crew at least 3 times.
And it was my understanding, Judge, that all those delays were for medical reasons, which I often stood down when Mr. Fink called me and said, hey, we got an issue. Can you stand down and wait a minute? And I did every time.
Okay. So, and Mr. Wasbury, if he hadn't paid the 264 in, nobody would have it. So, I mean, the reality is he paid it in, and so I think he gets that back. And then that's going to leave, if that's paid to Mr. Harrison, that's going to leave 1195 in. $769. I'm going to round that up so everybody can be upset with me. What I'm going to do is I'm going to give to the defendant $800 of the escrow, the balance to the plaintiff.
Thank you, Your Honor. How will the check get delivered to Mr. Harrison?
I think actually it will be sent to counsel, and then you'll have to make sure that that gets to him.
That's fine. I can take care of that.
All right.
Thank you, Your Honor.
Thanks, Judge.
Thank you.
Thank you, Mr. Wasbury.
Take care, Jim.
You guys. All right. To the plaintiff. Greg Pelton versus Chelsea Wallace.
Yeah, good afternoon.
Do not have Ms. Wallace checked in.
Chelsea Wallace, Clayton Taylor.
Yeah, I'm Tom Piotrowski on behalf of plaintiff. They may or may not appear. They have paid in full. I'd be moving to dismiss.
Oh, okay. Fantastic.
And actually, if the
All
court
right.
wouldn't mind, there was a default judgment against Mr. Taylor. I'd like to set that aside with the court's permission and then dismiss as to both.
Okay, that's fine. I'll dismiss it with prejudice. If you file the order indicating that, I'll sign off.
Thank you, sir.
Thank you. Hope you're well.
Thank you.
Thank you. Pines of Clover Lane versus Clarina Box.
Alex Lubyansky, P77121 on behalf of plaintiff.
She is not checked in. Would you like to take it? Well, this is her motion, I think.
Yes, I have this as a motion to set aside.
What do you have, counsel, as the current balance?
With the receipt of 3,000 that the court has acknowledged to have sent to our office, it leaves $2,579.34.
Okay, I'm just looking to make sure we closed everything out. We did. Out of our escrow. All right. I don't know what stage we're at. I don't know why they're not here. So I'm going to indicate motion denied. Defendant failed to appear. And you guys have what we sent to you. And you may proceed on your writ if you already have it. I don't know if you have it though.
Thank you, Your Honor.
All righty, thank you. Court calls the case of Sutton Ridge 1 versus, got this up. Looks like Lee Anderson. Or Leigh Anderson.
Alex Lubyansky, P77121 on behalf of plaintiff. Your Honor, we've received payment in full and are dismissing this matter.
Case is dismissed. That's without prejudice. And Sutton Ridge versus Duffin, that matter is dismissed on plaintiff's motion without prejudice. Is that it for you, sir?
Have a great
It
weekend, Your
is.
Honor. Thank you.
You do the same. Quishan Liu versus Hannah Crosby.
Yes.
Good afternoon, Your Honor. Adam Cadro, P74644 on behalf of plaintiff.
Hannah Crosby?
I'm here, Your Honor.
Okay, there she is. All right. And where are we on this, folks?
I spoke to Miss Crosby this morning. It did not go well. I don't want to get into the details, but yeah, but I wasn't able to make any headway or have a conversation with her about exactly what we need to do, what she's sort of disputing here. So that's kind of where we're at, Your Honor. Nothing has been accomplished.
Ms. Crosby, what would you like to tell the court?
I don't know that nothing has been accomplished. It's just a growing total. It's grown almost $10,000 now since the first time I came to court for this. And they said the costs were $900 and they just keep growing. I was first confused by the initial judgment that I got served. I then got served somebody else's gap bill at one point. I keep coming to these, but I paid the amount that it said. I paid rent during the time it said I hadn't paid any from February on. There was a previous, it was a 3-year term and I did get behind before. There was also a lot of other things that happened. My rent was raised. The original lease said it would be $28.10 my 3rd year. He raised it to $30.60 when I was having trouble already, and then raised my deposit. Charged interest is in this total of $20,000. I also put in a $10,000 fence into the house and did other improvements in the house. He never had to come out one time in the 3 years. There's a water main break in the front yard that I took care of. I've submitted all those pictures. To say I owe this man $23,000 is just not, I don't even know where to start of arguing, because I'm looking through this letter and
Okay, all right, hold on a moment. Let me, counsel, what do you have as the balance?
What I have as the balance is, hold on just a second, Your Honor.
You just sent me a letter that said $23,000.
Hold on, Miss Crosby. I'll let you talk, but hold on.
Sorry.
I have $11,655 in rent, $4,393.29 in water, $4,746.87 in damages, and $405 in court costs.
How much?
$405 in court costs.
405?
Yeah, it's a money judgment. So it's $215. We served her.
I got it. I can do that math. I'm just trying to figure out the other math.
Sure.
So there's a $4,000 water bill?
Yes, Your Honor. That we had discovered, my client received it in September. So Ms. Crosby saying things keep coming up. Well, Your Honor, my client unfortunately was taking care of his sick mother who has since passed. He was trying to deal with all of this. We had the court case, so we were going through. He was trying to get estimates of certain damages. We had obviously this water bill came in.
Where? Okay, hold
I
on.
didn't even have it in my name.
Hold on, Ms. Crosby. Hold on, please. Please, I will let you talk. I'm trying to figure out. So where's the 23,000 come from?
There's the ledger, Your Honor. There were a couple of things from the ledger that I took out that I had sent into the court in that time. So the big chunk of it, Your Honor, is we have $16,048.29 in rent and water alone. And then, like I said, $4,746.87 in damages. Your Honor, the Ms. Crosby talked about this interest. My client did not charge interest on anything. There was an agreement that they had made in December of 2022. Ms. Crosby, in an email that I submitted to the court, says that she owed a balance of $16,895. She had agreed to pay my client more than this to allow her to stay because she was going through some things. And so they came to this agreement. She said she was going to pay more. My client is new to this country, doesn't speak English very well. So on the ledger, it says interest, but in no means did he charge interest. When we went through this, said, okay, we're not going to add those in. So that's where there's kind of been some changing as to what has been owed on here.
All right, Ms. Crosby, you're still in the premises, is that correct?
No, I moved out at the end of the lease term, July 31st. I received this when I was moving out already. I'd already given notice.
Your Honor, we filed money judgment.
So
Excuse me.
hold on, was there a security deposit?
Yes.
Yes.
How was that applied?
The $4,000, it has not been applied yet.
It has not been returned either. Yeah.
Your
Okay,
Honor,
well, that
has not been applied yet because we were going through this process and trying to figure out what has been determined, what was owed, and then, we're going to.
So hold on. Do we have the damages? Was there a list of damages sent?
Yes, it's sent into the court, a list of damages, Your Honor.
Well, no. Was there a list of damages sent to Ms. Crosby?
I believe so, Your Honor. I know that she had asked about the security deposit, and I know that we had sent her through the court process, had sent her damages the rent roll of what, or the ledger of what was being claimed.
Counsel.
Yep.
She moves out at the end of July, I think she said, right?
Correct.
Okay. You had a forwarding address for her?
Not at that time, no.
Okay. So at some point we have an address.
Correct, Your Honor.
Mm-hmm.
Do we send her what's happening with her security deposit?
She had asked about it, Your Honor, and I had responded in an email. Yes.
Okay. All right. So she asked about her security deposit. Well, gee, what did you say in the email? I guess I'll ask that.
I said that currently your balance sits at X amount and that it be applied to the outstanding balance.
Yeah, he says X amount right now because it was much, much lower than it is now. And that it would be applied. I had actually exchanged texts or emails with Paul, and he said security deposits cannot be put towards rent. And I realized that because I had said something about using that when I was still living there, using my deposit. And he said, no, that can't go towards rent. So he knew the rule then. I then brought up to the attorney, here's my forwarding address. It's almost to 30 days. I haven't heard anything about it or damages. And at that point, the one time I had heard damages, it was $900. And all they were listing was like cleaning the carpets and painting. That's normal turn cost. And I had already paid a $350 fee.
Okay, people.
Yeah.
All right. So, when are we going to try this case? Because I don't feel like doing it today.
I'm open, Your Honor. I can't do it next week. I can probably do it the week after.
Okay, so
my client is also here as well, if you'd like to speak with him at all.
No, not really. So let's do this. I'm going to give you guys a non-jury trial date. You guys bring everything you have, and it just sounds to me like we're going to just have to sit down and go through everything. because that's why you can't agree. And I'm just gonna let you know, counsel, got a bit of a problem where the tenant moves out in July and the 4,000, I guess it is, in security deposit hasn't been accounted for on the account. Either as applicable to damages, which I think she's disputing the damages, or as to the rent. Because the problem with that is that your whole, okay, and every landlord out there listen to this. The 4,000 that you hold as your client holds as security deposit is not his money. That 4,000 is the tenant's money and always has been from the time they paid it. And so the difficulty is you've been holding the tenant's money, haven't applied it, and are going through this process arguing about other things. I'm also a little bit worried, I will tell you, so that everybody knows what I'm going to be looking at, about the water main break outside the premises, because I have a $4,000 water bill, which, okay, I have to get used to the concept of paying water because I'm on a well, but I don't think it's supposed to be that high.
I agree, Your Honor. I was shocked to see it as well. I have no evidence.
And
that she had paid
okay, but if something broke outside the premises, that's not going to be typically the tenant's responsibility.
Correct, Your Honor.
And as to not only the repair, but then also what then comes from that, which would be which may be the excess water usage.
Yeah, Your Honor, if I may, we, from the bill that my client got, she had never paid a water bill according to the bill that she had got. That's my client's understanding.
Did the lease say she was supposed to?
Correct, Your Honor. Yes, it did.
Well, where'd the water bill go to?
To that home, the tenants.
Are we sure, or did it go to the owner?
Hey, Paul, will you answer the judge, please? I believe it went to the tenant.
Yeah, this bill go to the house where the Hannah lived. From the very beginning.
Somebody's gonna have to show me that.
Okay.
And then somebody's gonna have to say that she's responsible for the 4,000.
I will. I'll make sure.
Okay, so here's part of my problem. I'm just
And
gonna let you guys know. I've been doing this for a minute. And so what I can't figure out is how anybody gets to a $4,000 water bill without the water being shut off.
That is, they add always only a late fee, but never paid. You can call
I'm not calling anybody.
But
Sorry, I will make sure that we get a appropriate water bill for the time that the tenant was in the property and what was paid.
Yes.
Hey, all right, this is gonna be fun.
I was hoping we'd be able to work something out. Maybe we will be able to. I don't know, Your Honor. But
well, I seen you guys like 3 or 4 times now. That ain't gonna happen. I mean, I can dream, but that's not gonna happen.
So can I. So can I.
November 20th.
All right, folks. What time? 9?
Yes.
Yeah, don't say anything else. No, November 20th. Will
Okay.
that work?
Monday, November 20th. That will work for me, Your Honor.
Is that a Monday? I'm gonna come off of the weekend to this. No, I'm kidding. All right. No, it's okay. It's okay. I'll be good.
I was thinking the same
Don't
thing.
anybody
Your
worry
Honor.
about me.
It's Turkey Week or something, right? I don't know.
Yeah, I know, but then I'm gonna rush to get to Thanksgiving. You guys are gonna hold me up, and this is gonna be a mess. All right.
So,
All right, here's what we'll do. November 20th, 2023, 9 a.m. That is in person, folks.
in person.
Okay.
So everybody bring all of your documentation, electronic or otherwise. I want to see everything, and then I'll hear everybody and we'll make a decision on it.
Great. Thank you, Your Honor. I appreciate it.
All righty. Thank you, folks.
Thank you.
Have a good day.
Too late, but I will. South Washington Properties versus Rebecca, is it WmCXlRlg? That matter's dismissed on plaintiff's motion without prejudice. Andre Gilbert versus Marcus Hollis.
Judge Schemke appearing on behalf of and with my client, Andre Gilbert, who's with me by Zoom. Andre, you can tune in and start your video. I see that the defendant is also present in the courtroom, Judge, by Zoom.
Yes, by Zoom. Marcus Hollis?
Yes, sir.
All right, you're here. Okay. All right, so, and Mr. Schemke, it's been a while. Welcome to the game here.
It has been a while, Judge. It's good to see you again, as always.
Good to see you. Okay, so we have a problem here. And I suggested to Mr. Gilbert that he talk to an attorney because here's the problem. The notice to terminate that was sent, the notice to terminate tenancy just says, I'm terminating your tenancy. So as I understand the facts, defendant has a lease to the premises. The notice to quit terminating the tenancy just doesn't give a reason. It just says it's terminated pursuant to the statutory section of 554-134. That's a typical, and that box is the box that's checked. The other box, other, is not checked and doesn't give a basis for the termination. That causes a problem when there's a lease that's in effect. It causes a further problem because then the initial complaint just says it's terminated by notice to quit. That's a typical 30-day termination, ideally where there would have been no lease or a lease expired. So there would have been the option of correcting, and I received, I think, an amended complaint, which then indicates that it checks a bunch of boxes, but it checks terminated by notice to quit, terminated per provision in lease, paragraph 9, which I think the last time the parties were here we went through, and then has an attached spreadsheet showing payment.
But it
so
also
here's the
says
problem.
There's 3
ahead,
consecutive late payments, Judge.
Pardon?
It's terminated for 3 consecutive late payments.
Correct. I had a feeling that that's what's being said. Here's the problem. The notice to quit doesn't say that.
So the notice is defective, is what you're saying?
The notice is defective. Because the notice is defective, I don't have subject matter jurisdiction. The notice isn't defective on the face of the notice. The notice is defective because of the complaint that's filed.
I'm all right. Let me be very clear, Judge, because as you know, you don't see me very often, and I don't really know this stuff as well as you do. Can you
Nobody
clarify
does.
for me? I know that.
Go
I do
ahead.
know that. What exactly should the notice have said in order to have been right so that I can get this next time?
And I'm not attempting to try to give legal advice. The
I'm not,
notice,
no.
right. I'm just, and I'll answer the question because I think it's relevant to the court's decision that this case has to be dismissed. The notice would have to indicate the reason where he has a lease that he's terminating pursuant to that provision. So the defendant has to have notice that that's why his lease is being terminated.
Right on.
And then the complaint would match that. But one of the reasons I wanted the plaintiffs to talk to an attorney was because when I saw it last time and there was an explanation, I did not think that there was a way of correcting it, but I didn't necessarily have a basis and thought it might be able to be corrected if he were proceeding under a different theory by an amended complaint. But the amended complaint I got doesn't correct it. It makes it worse.
All right. So what I would ask, Judge, under the circumstances, is to be allowed to put this over for 14 days and to be allowed to file yet another amendment to the complaint. And I will file a complaint to recover possession for non-payment. And we will proceed.
Oh, whoa. Is there a notice? Is there a non-payment notice?
There will be, Judge.
Okay, then that starts a whole nother case. If I get what you're trying to do, Mr. Shimke, and I understand it kind of. The problem is, from a procedural standpoint, if he sends a notice for non-payment at this point, that would be a different case. That doesn't mean this case can't exist with it. I'm not saying that, but that would be another case because certain other rights then attach to the defendant.
I'm just trying to save the filing fee, Judge.
Pardon?
I'm just trying to save the filing fee.
And we, like with any good court, are trying to get it. No. So I understand, Mr. Shimke. I'm just indicating that I don't think.
You don't think that's possible? I get it. I understand, Judge.
Yeah.
I thank you. I get it.
I will be more than happy to put this over 2 weeks. I have to do 1 week or 3 because the 10th is a holiday for the court.
But in order to cure the notice issue, I need a minimum of 30 days.
Correct. Right.
So
I think that, yes, absolutely.
And I can.
So then let me do this. Then you guys can do whatever you want. What's 30 days? I'll adjourn it.
So 4 weeks, we're actually going to come shot. It will be December 1st.
But he's got to have well, that's all in November though, right? Right. So if they get it out, cure it before the end of the month. Okay. So I'll adjourn this matter to December 1st, 2023 at 11 a.m.
The issue is, Judge, that depends on service today. Could we pass
that would
this?
depend on service by Halloween. So you got a few days.
If you say so, Judge. All right. That's fine. Let's do
All
it.
right. Okay. Thank you.
Thank you.
Take care.
Bye-bye.
Bye. Edward McConnell versus Mary Zamora.
Mary Zamora here.
Edward McConnell? You need to unmute, sir.
Okay, we okay now?
Yep, you're okay.
Okie dokie.
All right.
And did you hear me, Mary Zamora?
Yes, I hear you, Miss Zamora.
Okay, thank you.
All right, this is being terminated. Is this a month-to-month lease?
It's going to be, that would start in November, yes.
Okay, so
Solution
We sort of have a solution, we hope.
for the red issue.
okay, except okay, folks, what's your solution? And then I'll get back to the notice part.
Mary, go ahead and tell them what you think.
I thought the landlord and I were going to do a COD, a condition of dismissal, once all the back payments are paid, which he has the final amount due, which I think is $6,234.12. Is that correct, Ed?
How much did you say? Couldn't hear all that. $2,734.
That's after we get the contributions from other people. Yeah.
Correct. She's
Oh.
getting contributions from two other sources. And we got
Okay.
2734.12.
Is that what are the other sources?
SOS Community Services and the Housing Bureau. 3,000 from SOS and $500 from the house. $500 from the Housing Bureau, and the balance from me, which should be $2,734.12.
Okay. Amy, is she anywhere in the realm of that other funding happening?
Your Honor, I do have notes from the caseworker stating exactly what she just said.
Okay.
I'm
So let
sorry,
me ask
what was
this.
that?
She said she has notes from the caseworker that's working with you from SOS that it matches what you've
Yes.
said. Okay.
Alicia.
So
Alicia.
let me ask this. Okay. All right, Mr. Moore. Amy, does it matter that a court case is going, or can that still proceed without a court case?
Well, it looks like there's some agreement about a COD needing to be put together because that amount is above the 3,000.
Right.
And so I believe that the agency would need that written down to.
Right. Okay. All right, folks.
And we can do that.
Okay, so you, all right, Mr. Moore. All right, guys, listen. I appreciate you guys working it out. I really do. There are some
Sticky wickets.
here. Well, yeah, here's the problem. Just like the last case, the notice to quit that you served is not a proper notice to quit. Because at the time you served it, she had a lease. And you served it as though she doesn't have a lease. And then when you filed your complaint is not a non-payment of rent complaint. Okay? Your complaint is a termination of tenancy but your basis for terminating is not paying the rent. You can't do it that way. Okay, so.
Just what?
May I say something?
Oh, yeah, go ahead. I don't know if I can stop you, but go ahead.
Okay, thank you, Judge. Wouldn't
Yes,
the
ma'am.
COD, wouldn't the
A COD is a COD is a conditional order of dismissal.
Correct, correct. Wouldn't the COD, once we put that in place, fill out the paperwork, get it to the court, stating how much is owed and what the plaintiff, Mr. McConnell, would accept? You know, both of us have to sign that COD. Wouldn't that take care of this case, Judge Simpson?
Technically, no. And here's the reason why. Because the jurisdiction of the court really hasn't happened. And I don't want to go into a long legal explanation of that. Okay. All right. Okay, here, folks, you guys are trying to work this out, and I really do appreciate it. So here's how we're going to try to correct this. Okay. Mr. McConnell.
Yes, sir.
And I'm not here to give legal advice. I'll give you suggestions of what you need to do. Okay. You can follow them or not. I'm not giving legal advice. You need to get what's a demand for possession for non-payment of rent.
Okay.
Okay, from the court or from the website. Fill that out.
What's it called now? I'm sorry. It's called a what?
It's called I think the technical name is a notice to, we call it notice to quit for a non-payment of rent.
Okay.
Need to get that from the court. Fill that out.
Okay.
Send that to Ms. Zamora. All right, Ms. Zamora, so you're going to get another piece of paper from him.
Can I just mail it to her or can I deliver it by
Yep,
hand?
you can mail it to her. That's fine. That's a 7-day notice. Wait till the 8th day, and you're going to have to come in and open a new case. You're going to have to pay a filing fee and all that stuff. Sorry. And you're going to open up a new case. When the complaint that you file, you want to file a complaint for non-payment of rent. Okay, so make sure that that's the form that you get and fill that out.
Okay.
All of that needs to then get served. You know, once you file it with the court, it needs to get served on Ms. Zamora.
Okay.
So what that will do is that gives a case that a COD can come off of that Amy from OCD was talking about.
Okay, can you repeat? I'm sorry to, make this longer, but you're asking Mr. McConnell to get a demand for possession, a notice to quit for non-payment of rent. After
Correct.
7 days, after 7 days, on the 8th day, he's supposed to open a new case.
He has
And
to
that new
file that
case-
with the court and then get that served on you.
Okay, then once he serves me, then we can base a COD on that?
Yes, ma'am.
Okay,
If,
because,
let me mention, Your Honor, we've discussed this at length, Ms. Moore and myself. And I talked to Alicia, the SOS people, and their payment is contingent on her paying her amount. Otherwise, they don't pay anything. And she claims that on November 4th or the 5th, she's gonna have everything that she owes, and then the other people will pay the other portion.
Right.
So that we hope will happen.
This is gonna do.
Right, but work with them as to how that gets paid to you, because you're gonna have to have a ledger. I just need you guys to do that so we can try to make what you guys are trying to have happen.
I got you.
So do we have to jump through all these hoops before we can pursue the COD?
Yeah, I need that to happen. Okay, because I can't do anything on this case. Legally, I can't.
If we sign the COD,
Oh, you're muted.
Who's muted?
if we do put together a COD and she pays everything, we could just drop the whole thing, correct?
Right, but
If
yeah,
Mr. McConnell
drop the
and
whole thing.
if-
Listen,
can Mr.
folks,
McConnell, okay,
I'm just telling you how to do it because you're gonna need a COD. And I want to make sure that what you guys are trying to do can happen and that a COD would be in a proper form so that the monies from SOS can get paid.
Okay.
If you guys find another way to do it, more power to you. I'm just
right.
Okay.
You mean
Here.
because what we want to do is not to pursue legal counsel, which may or may not cost more. And Mr. McConnell and I would like to arrive at this agreement where if
Mr. Mora, I've been doing this a long time. And like I said, I appreciate what you guys are doing, trying to work with each other on this. And so I get it. I get it all. I'm just trying to make what you guys want to happen and trying to give you a way to do that.
Okay.
Okay?
Okay.
Yes, sir.
So what I'm going to do in this case, there may be a lack of subject matter jurisdiction on the case, but I won't make that ruling on this case. I'll adjourn this case out to November 17th, 2023, 9 a.m. So get that process started, sir, so we can try to match up these cases so that you guys could be done.
Judge,
Pardon?
can we push it back a few days? I've got a doctor's appointment. It's
I can do November what?
Wednesday, the 22nd.
I can do the November 22nd, or I'd have to go to December 1st.
22nd.
Which would you want?
The 22nd is fine.
Okay, November 22nd.
At what time? At what
And
time?
that's at 10 a.m.
On the dot,
10
right?
a.m.
Yes, ma'am.
Okay.
All right.
Yes, sir.
Thanks, guys. We'll see you then.
Let me ask you a question, different
Okay.
question. If for some
Uh-oh.
reason, just if everything, let's just say all her thoughts all come together and she pays me, can I just go into the courthouse and tell them we're done? Or do I have to actually come?
Yep, absolutely.
Okay, so we wouldn't have to come and do the Zoom thing.
That's right. I'd miss you guys, but you wouldn't have to come see me.
I know you would. Maybe we'll just do it.
Okay.
Okay.
All right.
So
You guys take care. Have a great weekend.
What's their website?
We get
okay, thank you.
the form, we get that form from the courthouse, right, Judge?
Yes, sir.
Okay, thank you.
Thank you.
Yep, thank you. What are you talking
He
about?
said you could get it online.
Uh-oh.
Oh,
Mr. McConnell, were you supposed to ask me something else? Because somebody's in your ear, so you better do it because you're muted though. Oh, you're muted again.
where do I go online to pick up that form?
For Michigan.
What's the site?
It would be courts.michigan.gov.
Say it again.
Courts.michigan.gov.
Courts.michigan.gov.
courts.my.gov.
Yes.
Okie dokie.
Gov.
Okay, thank
All
you.
right. Thank
Yes,
you.
sir. Thank you. Bye.
All right. Court does call the case. Pat McLaughlin versus James Anderson.
Good afternoon, Judge. I'm Pat McLaughlin, the plaintiff.
This thing won't close on me now. I kept turning around.
Mr. Anderson.
He's here. He's at the access point.
Yeah,
Is he still there?
I don't know.
Is he in the dark?
Uh-huh.
Can somebody check? We'll send a clerk in. I don't know if he left the room or went to sleep and the lights went out. Yeah, we got pretty much everybody. Who's the lawyer? Oh, Cheryl. Look up. Okay. Mr. Anderson? All right. Is it 2:00 already? It is.
Yeah, it's just after.
This is my last case in this block.
Correct.
All right, Mr. McLaughlin, I'm going to pass your case for a moment. Mr. Anderson was in our act. Oh, there he is. All right, never mind. I'm not going to pass. Mr. Anderson, can you unmute? Okay, can somebody help him unmute? Just hold down the space bar. Just a minute, Mr. Anderson. We're sending somebody in. Really? Okay, Mr. Anderson.
Yes, Your Honor.
Okay. And what's the claim in this case? I think there was a default judgment that was entered. You, Mr. Anderson, this is your motion for relief from judgment. Why didn't you show up at the first hearing, sir?
The first hearings is that I called, but I'm having trouble like I was having today. And when I called the clerk said I wasn't even in the computer, that I wasn't even scheduled to be seen by you today. So that was a computer. I don't know. I called. I got it on the computer. I even called the clerk office, and the clerk said, "You ain't even supposed to. We don't even have you on a list to even see the judge today." And I was like, "Oh, okay." So I went back to work. But this is the third
Mr.
time.
McLaughlin?
Yes.
I see your motion, sir. Mr. McLaughlin, who owns this house?
Uh, it was so long ago. It might be me and it might be PJM Investments, but I am the landlord on the lease.
Yeah, but who owns the premises?
I'd have to actually go back and look at the paperwork. It was 20 years ago.
All right. If the LLC owns it, you can't come in to do this. So let me do this, folks. I'm going to adjourn this case out 1 week, November 3rd. Go look at your paperwork. That's November 3rd, 2023 at 2 p.m. Go look at your paperwork because that may be a basis upon which the judgment gets set aside. I'm not even dealing with the repair issues he's claiming because I don't even know what those repair issues are.
Okay.
But I have to have the right owner on the property. Okay?
I will find out.
All right. Thank you. Thank you, Mr. Anderson. We'll see you in a week.
Yes, sir, Your Honor.
Will this roll right in? Wow. Dornbush had 2 and Luckoff has 2 cases. What's up with that? Slow down. Arbor One West versus John C. Hyman.
Good afternoon, Your Honor. Cheryl Luckoff on behalf of the plaintiff.
Mr. Hyman?
Yes.
All right. And where are we on this? Because there's a Section 8
Your Honor.
issue.
Yes. There was a Section 8 issue. His Section 8 was terminated due to criminal activity. The defendant indicated last week that he was working on resolving this with Section 8, and I had requested a judgment last week. You gave him a week to come up with some type of resolution or paperwork or something to show that.
Okay, now, Your Honor, what she's saying about the new charges, it was for a felony assault that I was found that was dismissed, Your Honor, and I got the paperwork for that. And it's
that's fine.
It's the technical.
I'm more worried about your Section 8 termination.
I know that's why they terminated me because of this, because it's a technical error. They got no data. Section 8 got no data on the information on that case. So they don't know if it's terminated.
Are they reinstating your Section 8?
Yes, yes, I got a hearing to provide the same paperwork I got now, Your Honor.
When is the hearing?
I don't have no control of the hearing, but they set the hearing to December 6th.
Whoa, it's not gonna work.
So I've been talking to, they've been emailing me, and I went down to the office and talked to the office about this to see if the office can contact them because, they set me a hearing to present the same paperwork that they technically terminated me. They terminated me for not having, or because they don't have the correct information for, Your Honor. And I got it. I went down to the courthouse to get it, and I faxed it to them already. So I don't know why they gave me that long court date, or not court date, but that long hearing date. I don't know why they gave me that long hearing date. And this is,
but you, sir.
Yes.
You got to make sure that they get that information to the landlord, because the landlord's entitled to a judgment at this point in time because rent hasn't been paid.
I went down to the office and I gave them the same information. So this was just yesterday. So they have the same information that they faxed over. And they email.
Sarah, do you have something that says you have a hearing date on December 1st or December whatever?
I can email. Yes, it was emailed, but I can email my apartment complex because yes, it was emailed through my housing complex.
All right. Here's what I'm going to do, but because this figure is just going to go higher. How much rent is owing, Ms. Lucka?
Your Honor, at this point, including court costs, it's $4,563.84.
And they normally pay the rent. They always normally pay the balance when these mishaps happen. So it ain't just not, they not just not gonna pay the balance.
Well,
It's
Your
just
Honor,
got
my concern, I'm sorry, go ahead, Mr.
I'm
Hyman.
just fixing this technical error that is not my fault for them not having the information on me on a charge that I'm innocent of. It's not
All right,
my
Your
fault.
Honor, here's the problem. The problem is it actually is the defendant's fault because the defendant didn't respond. I mean, this has gone on. This has been months and months and
I
months.
wasn't able to respond, Your Honor. You know that I wasn't able to respond because it was an issue that needed to be fixed with the mailboxes that was kept getting broken into, that was easy access. And I said that at court hearing, and I went down to the office and complained about this.
Mr. Hyman.
Yes.
Did you tell the people, look,
Your Honor,
you're not going to talk over me. That's never going to happen. Did you tell the people at Section 8 the predicament that you're in with this rent?
Yes. I'm waiting on it.
What did they say?
I'm waiting on the email as we speak. They set, Your Honor, they set this hearing to December 6th, and I immediately emailed them and told them that that's not possible if I'm facing eviction. I already sent them my eviction paperwork because they had already been paying my rent. Your Honor, this came out of the blue because I haven't been getting my paperwork. So I wasn't able to get started with any of this process until I received the eviction notice on my door.
All right, Mr. Hyman, here's what I'm going to do. There isn't a tribal issue at this point for the court to do. I don't know the ruling from Section 8. I'm going to grant the judgment to the plaintiff so we can lock in at least the figure. You've got to figure out how to get to those people at Section 8 that they will indicate that they will pay this back balance. That's what I need from them.
Okay.
Also going to suggest to you that you do is legal aid has walk-in hours, and you can walk in to speak to them on Tuesdays between 10 to 11:30.
1 second, Your Honor, I'm writing this down.
Okay.
And the first thing you said, Your Honor, what was that again?
Which part?
Not the legal aid part, the very first part.
I'm giving, you need to get something from them telling everybody that they'll pay the back balance if what you say is correct as to the termination. That's the first thing. The next thing I'm going to tell you is that you need to go talk to the folks at Legal Aid. They have walk-in hours at 15 South Washington in Ipsy on Tuesdays between 10 to 11:30 and on Thursdays between 2 to 3:30. And you need to take all your paperwork down there to try to talk to them. But in the interim, I'm going to give the judgment because this balance is going to go up come Wednesday.
What was, I'm sorry, you said Thursday. What was Thursday, that Thursday time?
Thursdays between 2 to 3:30. And I will, so that you have time to at least have that looked at, I'll extend your writ date in consideration of granting judgment to the 13th of November. But you've got to get down there. You've got to get all that paperwork, Mr. Hyman.
I will. I'm constantly talking to him, so it ain't like I'm not doing nothing, Your Honor.
All right. Thank you.
All right. Thank you.
Arbor One versus Akiba Tucker.
Good
You're
afternoon,
welcome on
Judge.
behalf of the plaintiff.
Okay, Ms. Tucker, hello.
How you doing?
I'm doing okay, I think. We'll see. Okay, you were supposed to get me an answer. That was a while back. Where are we now? That's
So Your
just
Honor,
a heat
last week
exchanger.
when we were here, all the ductwork had been completed and the issue was then the furnace had a crack. So the landlord had to replace the furnace, which the landlord did replace the furnace.
Yes.
And at this
All
point, we're
right.
asking for entry of a judgment.
All right. How much is owing?
Your Honor, rent to retain is $6,037.02. Court cost $200. The total bill is $6,237.02 minus any escrow that Ms. Tucker would have placed with the court.
Which is $990. All right. Ms.
May I
Tucker, how
speak,
are you gonna get that
Judge?
paid?
Yeah, so it was interesting. You just mentioned the court office for the previous individual. I actually finally got to speak with an attorney. I've actually been advised to take this to trial due to the circumstances of this case that I have not been able to discuss with you, unfortunately, but I've been advised to take this to trial.
I would ask the court what the tribal issues are, because at this point, every single repair has been done.
I have no problem sharing that if I can do that now.
Go ahead, give it to me.
Okay. I called and talked to Amy yesterday and I informed her that I've seen my doctor and I've seen the emergency room physician. I have not spent a single night in my home since June because of the conditions of the apartment with the not ventilation and all these different things. My asthma was exasperated to a level I could not even stay in my own house. I
Are
have
you
only
gonna
gone there
have,
to shower.
hold on. Are you gonna have an attorney represent you?
Yes, sir. They just said I had to do this part first.
Who is gonna represent you?
I don't have her name. The lady that was at the place on Washington. I have to find her. I got her card.
Your Honor, this is like
somewhere.
the fifth hearing and there's no appearance filed by an attorney.
I know.
Well, I was just able to get an attorney, ma'am, because I tried to go through legal services and I didn't have any luck. So I actually had to go outside of that to get assistance because I have proof for everything that I am stating here. I just don't have.
But Your
any way
Honor,
to
an
just
answer
put
was
it out
filed.
there.
There was nothing put in there that she wasn't that it wasn't habitable and she wasn't sleeping in the unit. So this is all new. And I said last week I was concerned.
That's because I didn't understand that I could put that there.
Issues.
I can prove all this going back to there with documentation from my doctor. I was not aware that I could put that there. I have never been a part of eviction before. I thought the only thing I was supposed to do was list the repairs. That's what I did. So I didn't get a chance to speak up until now.
How much is monthly rent?
$1,350, Your Honor.
What was it? 1,000?
350. And she hasn't complied with the escrow order as far as
because
I don't believe.
I have not been able to work due to my asthma, which I haven't been able to tell you guys because you won't let me talk ever.
Okay. Here's what we're gonna do. You want a trial on this? We'll have a trial on it.
Thank you, sir.
You haven't complied with the escrow order since September because you didn't comply with the October order, which you said you were going to get in on
Yes,
October
sir, but I
20th. You said you were going to put that in.
Yes, sir.
So,
I'm
and
paying
you
with
didn't
my
put it in.
federal
You didn't put it in, ma'am. You didn't put it in.
This is
So
why I'm asking for a trial
because
date.
you haven't complied with that, I'm going to grant your trial, but you better come with your stuff.
I got everything.
Quick. No, quick.
I'm ready.
November 7th.
And Ms. Luckoff, would you be available November 7th?
Let me check, Your Honor. Oh, boy. What time?
What time would work for you? Because
I mean,
it's
I
an
can-
immediate, I'll work with you on that because I know you weren't expecting a trial, so.
Thank you. I could. Anytime after, well, I would have to get up there. So I would say, yeah, 1 second. Let me see how many cases are up on this one. Ooh. Can we do it in the afternoon? Or would you, I mean, I can get someone to cover something else if it's better for the
We
court
could
to
do
do.
we could do 2 o'clock. Will that
Okay.
work?
Yes.
Let me check that. That's November 7th.
November 7th, 2023, 2 p.m. In person.
Sounds amazing.
So, Your Honor, just so we're clear here on the issues, because all of the repairs have been done. So what exactly are we going to trial on?
She's indicating that that the unit wasn't habitable, wasn't able to reside there.
That's what's
So I'm
not, that was not
presuming
in
we're
the
going to have.
answer. Oh,
Well,
okay.
but hold on. I'm presuming we're going to have something outside of hearsay testimony regarding what a doctor said. I'm presuming we're going to have bills. She's going to have to come through with everything. If she doesn't come through with everything, I have no problem issuing a judgment that day. But if
And
she
is she
wants to
going to
raise these issues.
Go ahead.
Okay, go ahead. I'm sorry. What were you going to say?
No, I was going to say, is she going to provide this to me before the court hearing? This information?
Yes. So, ma'am, any written documentation that you have needs to be supplied to plaintiff's counsel by November 2nd.
Am I able
So
to
Thursday,
email
you
these
have to
things?
get copies of whatever you intend to produce to the court to plaintiff's counsel by November 2nd.
Okay, am I able to email this to her, or do I need to walk it down like I had to do the other ones to her office?
You can email her. I think you have the email address.
Yeah, I just need that information, and I will gladly provide her all my documentation. It's a lot though, so I'm just warning you.
Okay.
Okay.
Anything else, folks?
Nope. Thank you, Judge.
Well, Your Honor, actually,
Yeah.
I'd like to have some money put in escrow. I mean, this is just, she just gets a free ride here. I don't understand why nothing's.
Oh, I got a free
What
ride.
I'm giving is an immediate trial.
Okay.
I've got about $1,000 in escrow, and that's why I'm setting a trial date so quick. And why
Okay.
we were going to set it for the 20th, but I'm setting it for the 7th.
Okay.
Okay.
Understood. Thank you very much.
Thank you. Appreciate it. You have a great day.
Only 2 cases, but not 2 easy ones.
No. And I did get the email regarding the meeting yesterday. You didn't